Rev'd Up by day.
Hi everyone, and welcome to the third episode of Rev'd Up by Death. As you can see, today's a bit of a different venue. We are at Robin Twaddle and Associates. We are here with Robin, and he's going to be discussing wills, leaving a lasting legacy, what to do and what not to do. Robin, please introduce yourself.
Hi Gabby, and thanks for having me on the podcast. I'm Robin Twaddle, an attorney practicing in Midrand. Have been for the last 30 odd years. Practice, we've got 4 attorneys and pretty much cover the spectrum of civil work, from company and commercial work to property transactions and obviously wills in estates and trusts.
Awesome. Thanks, Robin, and we really appreciate you being on the podcast. I think me and Gav briefly mentioned in episode 2 that I think this episode will get the most amount of traction, because often people just don't know what to do when a loved one passes away. I mean, you know, Gav.
Absolutely. We've had many instances where there's been confusion in terms of wills and estates, in terms of what loved ones wanted, not only from a financial point of view, but also in terms of final arrangements such as cremations and burials and things like that. So it really is a privilege for us to have access to your experience and to your knowledge, Robin. Thank you so much.
You're welcome. Thank you.
Robin, we've just, put together a couple of questions for you. And I think a lot of my clients ask, and I'm sure a lot of your congregation members ask these sort of questions. And also just for my knowledge, so that when my clients do approach me with questions like this, I know exactly how to guide them. And again, I can point them in the direction of Robin Twaddle and Associates.
Yeah, appreciate
it. Pleasure. So, Robin, can you just tell me, when it comes to a will, what is important to put in the will? Like, can you give us some sort of idea, like key components of a will?
Sure. Well, firstly, a will is more than setting out your wishes as to what happens to your stuff or your wealth when you die. So it's a bit of a fallacy that you have to be super wealthy before you need a will, or before you should have a will. Anybody whether you're just starting on your sort of journey of life and don't really have much to your name, or whether you're super wealthy, it's a good idea for anybody to have a will. And there are a number of reasons for that. Sorry.
No, it's fine.
Lost my train of thought there. So a surprising number of people believe that if you die without a will, your estate goes to the government, to the state, which is really not true. There's a law called the Interstate Succession Act that governs what happens if a person dies without a will. That only deals with succession in terms of assets and things, and it pretty much goes along familial lines. So if you die without a will and you are married without children, then the estate goes to your spouse. If you die without a will and you are married with children, then your estate is split between your spouse and children in equal shares. There's a proviso that the spouse gets a minimum of 250,000 Rand value. If you die without a will and you leave no spouse and children, then your estate is split between your children in equal shares. And if you die without a spouse and no children, then it goes up to your parents, and from there out your siblings and cousins and so forth, until eventually somebody's found. If no beneficiaries can be found, and that would be whether you have a will or not, if no beneficiaries can be found in existence, then your estate gets held in the Guardian's Fund. And every year a list of unclaimed estates is published for 30 years, and only after 30 years do those unclaimed estates then accrue to the estate, to the state.
I'm quite devastated that there's no option for the church if they can't find any relatives.
Absolutely, I'm sure that would be a good change in legislation.
I'm so glad you brought that up, because I was under the impression that if there was no will, the money does go to the government.
Yeah, no, that's definitely not the case.
Yeah, I actually can't believe. Thank you for clarifying that, and also again for my clients with the 250,000 Rand. Lots of people come to me and say, Gabs, there was nothing in the estate. So I always say to people, do it yourself. I don't know if you've ever guided someone on that, Gav?
In terms of drawing up a will for themselves, or in terms
when the estate's just worth...
in terms of executorship.
The 250,000. So if they say there's nothing in the will,
yes,
and they say, Gabs, there's probably maybe 100,000, I say, well, then you just do everything on your own.
What is the difference, Robin, with an estate less than 250?
So when that comes into play when it comes to administering the estate. So, and again, it doesn't matter whether there's a will or not, the same principle applies. So an estate that is a value of less than 250,000 Rand, there's a short process of winding up the estate. You apply for letters of authority from the Master of the High Court. Once you have those letters of authority, the person appointed simply goes to the bank, closes accounts, collects the money, sells assets, and distributes the money according to either the will or the Intestate Succession Act. With an estate that's worth more than 250,000 Rand, there's a more formal process. There's letters of executorship that are issued. The executor then has to advertise for debtors and creditors to come forward. There's a formal process of obtaining valuations and certificates of balance, etc. for assets. A formal liquidation and distribution account needs to be prepared and filed with the Master of the High Court. That lies for inspection for interested parties to come forward and object, and only then is the estate distributed. So there's a much longer and more complicated process. And that figure, that 250,000 Rand, has been in place for about 30 years.
Wow.
While I was doing articles, and I've been practicing for 35 years this year, and it changed from 125,000 Rand to 250,000 Rand before I qualified. It's been that since then. So you can imagine virtually any estate these days is worth more than 250,000 Rand. So it's time that the legislature looks at that and brings it in line with inflation.
Right, sure.
Sorry, I just want to go off topic for 2 minutes. Robin, I'm looking over here on the right-hand side, and I see you did the Cape Epic.
Yes.
That is awesome. So are you a lover of cycling?
I'm a lover of cycling. I've become a lapsed cyclist. I used to do a great deal of cycling, both road and mountain biking. I did the first Cape Epic in 2004. So that was the guinea pig version, which was great fun and a great experience and very challenging. But I've done a lot of road cycling as well. I've done many Cape Argus races. But when I turned 50, I took up golf. And that took care of my cycling days. I tried to fit both of them in, but found that it didn't quite work. I also found that I lost the love for suffering that comes with cycling. Because it's quite it's a very tough sport, that. So yes, I'm a lapsed cyclist.
In terms of suffering, me personally, I would have never studied law. So good on you for becoming an attorney.
Thank you.
And I also see on the left-hand side all your qualifications. Really well done to you, Robin.
Thank you, thanks.
Just back to our wills and
Yes.
estates. Are handwritten wills valid, and under what conditions?
So the requirements for a valid will are set out in a law called the Wills Act. And the requirements set out there are you've got to be over 16. So if you're under 16, irrespective of your wealth, your estate would be governed by the Intestate Succession Act. You presumably wouldn't have a spouse and children, so it wouldn't
We hope not.
be matter too much. So you've got to be over 16. The will has to be signed on each page and at the end of the will by the testator and 2 witnesses. It specifically says signed in the Wills Act, and it doesn't make reference to the Electronic Communication and Transactions Act, which makes provision for electronic signatures. So and there's also been no court cases surrounding whether an electronic signature would be acceptable. So I would say one's got to play it safe and have a wet ink signature. I often get asked by clients, can they sign their will electronically? And I always advise them rather a wet ink signature, so that you don't have the possibility of it being declared invalid for lack of signature when it comes to the Master of the High Court. When the Act says it must be signed at the end of the will, if the last page if the text ends halfway down, that's where it must be signed, at the bottom of the text. If it's signed at the bottom of the page and there's a big gap, it's not signed at the end of the will, and it may then be invalid. The witnesses must be over 14, and they must be competent witnesses in the sense that they must be of sound mind.
Can't be drunk.
They can't be drunk. The testator must be of sound mind and sober as well. And the witnesses can't be named in the will in any capacity, either as beneficiary or as executor. And the witnesses also can't be connected persons, spouses or children of any, or parents for that matter, of anybody named in the will. It's got to be an unconnected third party.
Yes, you learn something new every day, eh?
Absolutely.
And tell me, Robin, if someone drafts up a will and it is not signed,
Yeah.
and then the person passes away at home and the family are scavenging around the house, they find this will, but it's not signed, is it still valid?
It's not valid, so a valid will has to comply with those factors that I mentioned earlier. So, for example, a video will, which has become quite the rage in many cases, is invalid because there's nowhere that you can sign it. So you could leave a video will, but it's got to be backed up by a written document that confirms it. So you can have your family look at the video and see that is your will, but you have to have the document that backs it up. That is the valid will. So whether a will's simply unsigned because the person drafted it and never got around to signing it, or signed it incorrectly, either didn't sign each page or didn't sign at the bottom, that will's invalid. And the court does have the power, and this is also in terms of the Wills Act, if a document that purports to be a person's last will doesn't comply with the formalities required in the Act, then the court can, on application, declare that to be the person's last will. But it requires an application to court and convincing the court that is the case, which is obviously costly and takes time. I'm dealing with an estate at the moment where it was a sort of do-it-yourself will. The chap signed his will, his wife witnessed it, and another person witnessed it. His wife was the beneficiary or is one of the beneficiaries, and the first page, it's a two-page will, and the first page isn't signed. So the family there needs to decide whether they are going to apply to court to have that declared his valid will, or simply wind up the estate on an intestate basis.
Yeah, it's really...
What are the other mistakes that people make when it comes to drawing up a will? Have you experienced common factors that recur?
So the most common mistake, if a person doesn't have a will done by a professional, is not meeting the formalities, having the wrong people witness, ineligible people witness it, not signing in the right place, not signing the multiple pages if there are multiple pages, only signing at the end, and often just drafting it badly. If the will's ambiguous, then that can give rise to problems. If it doesn't clearly state what the person's intentions and will is, that can cause problems as well. So pretty much poor drafting and not complying with the formalities. Another common mistake is using these off-the-shelf forms that you can buy at the newsagents or download off the internet. Those often have different scenarios or different provisions that are sort of mutually exclusive. And then if people don't cross out the ones that don't apply, you could end up with a vague document that isn't really helpful to anyone.
Guys, so don't make these mistakes. Get in touch with Robin, Twaddle and Associates.
Absolutely. It's just so much safer to get someone who's qualified and in the know to draw up a will than to try and do it yourself.
That's right, yeah. And it needn't be an expensive exercise. People are tempted to either not have a will or do it themselves, or go to a bank or something because it gets done for free or cheap. But it's not an expensive exercise. Our tendency, if we nominated as executors, we either charge a nominal fee or no fee at all. A lot of our wills are done for clients who we do other work for, and we sort of do it as a service for them. So I would advise people, rather than assume that it's going to be unaffordable, ask the question and see if a plan can't be made if they're a bit tight on money.
Robin, how often should someone update their will?
So a will's valid until it's revoked or until the person dies. Well, it remains valid when they die, but it's valid until it's revoked. But it's a document that's dynamic. As life changes and as circumstances change, the needs in the will may change. We tend to try and anticipate changes like having children and so forth when we draft a will, particularly if it's for a young person or a young couple who recently married perhaps and don't have children yet. We can make provision for children to be born in the will. But generally, if there are life-changing events, if somebody who's nominated in a will as a beneficiary dies, you may want to revisit it and see if you want to reroute that beneficiary. A key thing would be if somebody who you've nominated as an executor dies, it's obviously essential that it then gets changed. So a will something that should be reviewed every few years, and certainly when there's a major life-changing event. If you have children, if you die, if you get married or divorced, it should be...
Or win the lotto.
Or win the lotto, yes.
Yes, please. Can we all win the lotto?
Yeah. And an interesting aspect, and this comes from the Wills Act as well, if a person gets divorced, then for 3 months after your divorce, if you have a will that leaves your spouse as a beneficiary and you die within those 3 months, then the will is interpreted or applied as if the spouse had died. So you've got 3 months to change your will, and if you don't change it within those 3 months, after the 3 months, then it's accepted in its form. But there's a period of 3 months where the law assumes that you would have wanted to sort of disinherit your divorced spouse.
Wow, so it's almost like a grace period.
Yes, absolutely. Yeah, it's an interesting. Not many people are aware of that.
Yeah, again, learn something new.
Yes.
Tick. Another question. Where should a will be stored? Like when you draft up a will for a client, is it stored in your office, in your archives? Or where should, if someone wasn't using your service, Robin, would it be stored in a bank in their archives? Is there like a vault? I don't really know.
So when we draft wills, firstly to answer your last question, there's no sort of repository or vault that all wills get stored. Only when a person dies does the will get sent to the master's office, and they then kept at the master's office in a particular room called the wills room. But there's no place where anybody can go and place their will. What we do, we have a safe custody facility where we give clients a choice. If we draft a will or any other documents for that matter, we have a safe custody facility where we can keep the wills and their title deeds or whatever. And we find most of our clients who do wills with us use that facility. But if a person wants to keep their documents themselves, it can be in their own filing system or whatever. But it's important that somebody knows where the will is. Because you often have a situation where somebody passes away, they haven't told anybody where their will's kept, and then it's a mad scramble to look for it, and you may find a situation where an estate is then wound up as intestate when there was a valid will lying around somewhere, and it may only be found many years later when the spouse might move and find something behind a cupboard or something like that.
It's not unusual. Yeah. So often I have families in my office,
yes,
and they're stressed, and they're going through flats or homes looking for wills and things like that. So that really is sensible advice.
Yes, yeah.
And that's actually a question that I ask at work quite often, Robin, is, the families will come and have an arrangement with me, and they'll say to me, I don't really know what mom or dad's wishes were. And I say to them, is there a last will and testament? Yes, there is. Oh, we can't find it. We don't know whether it's a burial or cremation. Personally, I'm no attorney, I'm just an undertaker. I think it is vitally important to jot down in your will whether you want to be buried or cremated. Because in the first episode, I actually discussed how I've had a family where the brother wants the mom to be cremated, but the sister wants the mom to be buried. So I don't know, do you advise that when you draft up a will? Do you say, stipulate whether you want to be buried or cremated?
Yeah, I think it's one of the things that are important to mention. And it's another reason why a will is important, irrespective of how much or how little you have, because it's one of those things that there's no legislation that provides for, like nominating an executor or nominating a guardian for your children. If you don't leave a will dealing with those things, saying who you want to be your executor, who you want to be the guardians for your children, whether you want to be buried or cremated, nobody's going to know. And then the family needs to make a decision. And if there are conflicts about those issues, then it can create conflict that could have been easily avoided by a will. And another aspect which has become fairly recent in our law and practice is a living will. The wills we're talking about they only really get, or they become relevant and get opened up and dealt with when the person's died. A living will expresses wishes for your care in your sort of last days sort of thing, or under certain circumstances, and that's also an important document. And possibly a better document to put wishes like burial or cremation in, because that document will generally come out while the person's ill or had an accident or something like that. So those wishes, very often people are reluctant to have a look at the will before the funerals happen. They think that it's poor taste if they want to dig around for the will and see what's in the will before the funerals happen. So a living will is probably a better place for those type of wishes to be expressed.
And it's absolutely important. I literally have just come from hospital where someone was resuscitated against their wishes, and they're lying in a vegetative state.
Yeah.
And so it's hugely distressing for the family.
Yes, absolutely.
And also very important that people know where the living will is under these circumstances.
Absolutely, it's very critical that. I mean, a living will, a will is definitive. It expresses your wishes and it can't be deviated from. A living will isn't prescriptive. It's really a guide for your loved ones, because the ultimate decision as to whether a person must be resuscitated or life support system switched off or whatever lies with the family. But the living will guide the family, and hopefully the family will then follow that person's wishes.
Right.
But it's helpful in the sense that you very often have a family member who feels that they must try and save the person at all costs, and there can be conflict, because there may be one who's a bit more pragmatic and says, well, mom or dad is never going to wake up and they're suffering and let's end it, and somebody else is kicking against that. Whereas if you've got a document that guides them, it helps on that level.
Absolutely. Very
I must be
sensible.
honest, when my gran passed away, I was looking through her files, and it was the first thing I actually came across. I didn't come across a will. I came across a living will.
Yeah.
And for me, I mean, I'm 28. I actually didn't know that there was a difference. So it's nice to have the knowledge from you, Robin, just explaining the difference between the living will and a normal will.
And it's important, and with a will, normal will, as obviously it's important, but in particular with the living will, it's important that you once you've done the document, it's important that you tell your loved ones where it is, and that if something happens to you, this is where they must get it. I've got an envelope for my children that if I have an accident, there's an envelope with my wife's and my will, our living wills, details of our investments and assets and PIN numbers and that sort of thing, so that if something happens, they know where to go to find these things and to be guided.
It's so sensible. Your banking PIN numbers, because I'll look after the envelope for you if you'd like.
You were just chatting about what you and your wife have listed in the will. I just want to ask a question. How many times do people actually list their pets? What happens to their pets?
That's become very common lately. It was very uncommon many years ago, but it's becoming more and more common. People's pets are becoming more and more important to them, and it's no longer a stigma of the mad cat lady and that type of thing. People are making provision for their pets, because it's a sensible thing to do, because and what I'm finding quite common is people will request that their pets are homed with somebody, and very often they've discussed that with that person and made sure that they're willing to take them. But then they also make a cash bequest to make sure that that person is provided with the means to look after the pets, to feed them and take them to the vets and that sort of thing. So that's become very common. A lot of people stipulate that if they die, their pets must be euthanized, which depends on the pet. If it's a very old dog or cat or whatever, that wouldn't easily be rehomed, it's not a bad thing. If it's a young pet that could have many years left, it's a good. So it depends on the person's wishes. If asked, I try and guide them. But it's become very common, to answer your question. It's very common to
Do you think we should advertise to look after pets if there's a bequest above a certain...
I think we should. Another source of income.
Robin, you mentioned guardianship as well. Is there a scenario, or have there been scenarios, or is it commonplace where children have been allocated, sounds terrible, to a particular guardian, and family members object and things like that?
Yes. So again, the nomination of guardianship is a guide in a will, because ultimately the court, and in particular the children's court or the high court, they both have jurisdiction, but the court appoints a guardian if a parent has passed away or is no longer there. Generally, the court will appoint whoever applies. If there's support from the family, the court will appoint that person. If there are conflicting claims on guardianship, if I can put it that way, that can create friction and difficulty, and then puts the court in a difficult position, because now the court's got to decide who's the most appropriate person. So nominating a guardian in a will then guides your family and the court as to who you would prefer your children to be placed with if you were to pass away and they're under the age of 18. And the courts will take strong cognizance of that request or that wish, and anybody who wants to either be appointed as guardian or somebody other than the nominated guardian to be appointed would have to convince the court that it's really not in the children's interest for the nominated person to be appointed, or the court would appoint them. Obviously, the court has to exercise its discretion. If you nominate somebody and it turns out subsequently things emerge or information emerges that demonstrate that they're patently not appropriate guardians, or it's not in the children's interest, then the court has to have the ability to deviate from the wishes, and a family member who is aware of such circumstances would be duty-bound to inform the court and to say that person is not suitable and this person may be more suitable, and that it is a strong guide.
How, and I suppose it's a difficult question to answer, but often folk would say, oh, my father wasn't in his right mind when he signed the will, or he was, starting Alzheimer's or something like that. How do the courts manage a situation like that?
So it's quite an uncommon situation, and the reason for that is it's very difficult to prove. A will can only be challenged or contested on the grounds either that it doesn't comply with the formal requirements that we discussed earlier, or that the person wasn't in their right mind when they executed the will. And it's the onus of proving that is on the person making the allegation.
Okay.
And it generally comes down to whether a person was mentally competent. The formal requirements are pretty easy. You can determine who the witnesses are and whether they were related or not. Whether the will is signed or not is quite common. So the only ground, if the will complies with the formal requirements, the only ground that somebody could object or contest it is on the basis that it's a forgery. But again, it's fairly easy, because it's a wet ink signature, it's fairly easy to have that determined by a handwriting expert. So it really comes down to the basis for contesting would be that the testator wasn't in their right mind. And the person who alleges that would have to prove it, and it's really a high bar to prove it. You'd have witnesses saying, well, we signed it and the person was fine. They understood what it was. Very often the will would have been signed in the presence of an attorney or professional, and that person would then testify that they explained the contents and the person understood it. So it's very difficult for somebody to prove that that's not the case.
Okay, that's helpful. Thank you.
And Robin, in my line of work, when you follow up for payment, there is always family disputes.
Yes.
Constantly. And you always say, the sister wasn't happy with the will. And I'm glad you said that. And it makes sense why there is two witnesses.
Yes.
Because if someone does want to contest, well, was that person in the right state of mind when they signed their will? The witnesses can say yes. So
Exactly.
I love that sort of point that you made there.
That's
that not
why,
everyone can just contest.
Yeah, exactly. It's a fallacy, and that a person can contest a will. You often have somebody that they're not happy with the contents of the will and say, I'm going to contest it. But it's not as easy as
Probably
that.
coming out of Hollywood and the movies and things like that.
Exactly.
Yeah.
And interestingly, and I think where that idea comes from, in some jurisdictions, the law has what they call a legitimate portion, where a beneficiary or a family member, a child or a spouse, is entitled to a minimum percentage of an estate. But that's not the case in South African law. Here we have complete freedom of testation. You can provide what you like in your will, provided it's not illegal or immoral or anything like that, but you can provide what you like in your will. So if you want to disinherit your spouse and your children completely in favor of the SPCA or the Presbyterian Church or whoever, you can do that, and your family's got no say in it. They may, if they were dependent on you, they may have a maintenance claim. A spouse, for example, would have may have a maintenance claim if he or she was dependent on the deceased. But a person, you can do what you like with your estate in your will. Nobody's got a legitimate claim, so you can't contest the will purely on the basis that you're not getting what you expected or what you hoped for, what you think you're entitled to. You're not entitled to anything.
Well, I think let's just emphasize on that.
Yes.
People think they're entitled.
Absolutely, yeah.
And that's where they throw around the contesting word.
That's right, yes, exactly.
Robin, and for myself and for the viewers as well, lots of people talk about an executor. What is an executor? Do we need to have an executor? And should a family member be an executor?
Okay, so an executor is an essential person in the estate winding up process. If you die without a will, then the beneficiaries have to, and it would be the intestate beneficiaries, have to nominate an executor. Again, it comes down to the importance of having a will, because again, there may be conflicting claims on executorship, or conflicting ideas as to who should be appointed as executor. So if you have a will and you stipulate in your will who you want to be your executor, then it takes away that potential for conflict. So the executor is the person who winds up the estate. The estate vests in the executor from the time he or she is appointed. The executor is responsible for the estate. The executor cashes in the policies and the investments and so forth, sells assets that need to be sold, deals with the estate, files final tax returns, and then distributes the estate to the beneficiaries. So it's a really important role. Who to appoint as executor? It's a administrative process. It's a legal process. So it's a good idea to have a professional involved. You can appoint a family member who would then appoint who may appoint an agent. In fact, generally the Master of the High Court, if an executor is a lay person, the Master of the High Court would insist that an agent be appointed who is a professional with experience in that role. So a family member can be an executor. If it's a spouse, it's not a bad idea, because you're then giving them the freedom. You're not imposing another person on them in that role, and give them the choice as to who they want to appoint as their agent. If it's not a spouse, I would shy away from a family member, because again, you come back to the conflicts. And in fact, I had that experience fairly recently where a chap died and his brother was appointed as executor. He didn't have a wife and children, so his extended family, siblings, nieces, nephews were appointed as beneficiaries. I think there were about 12 beneficiaries involved. And he had appointed his brother as executor, and there was a lot of conflict about that, with people saying, well, he's trying to milk the system, and, what's he getting paid, and what's he doing for what he's getting paid. So my inclination would be, if it's not a spouse, or if you've got more than one beneficiary, then not to have a beneficiary or family members.
So to have a neutral party.
Absolutely.
And an agent could be an attorney, for example.
Exactly,
Okay.
yes.
Yeah, I think I advise, just from personal experience,
Yes.
no family members. I think a neutral party, like you said, or the spouse.
Or the spouse, yes.
And in terms of banks, so often banks offer a service.
Yes.
My understanding is that they often charge a percentage of the estate and things like that.
So the estate fee, I think it's the Administration of Estates Act that stipulates the estate fee, which is 3.5% of the value of the estate, and 6% of the income that's earned between death and finalization of the estate. My difficulty with banks and institutions being appointed as executors is it's pretty impersonal. You've got a manager of so you deal with your banker or your financial advisor or your broker or whoever, but when you die, that person falls out of the picture, and the bank or the trust company's estate department then takes over and runs with it, and there's a estate department manager and estate department clerks who've never dealt with you. They don't know you from a bar of soap. They don't really have a personal interest in you, And I've had experience where clients have had difficulty, where there's a lot of money tied up in an estate and they can't have any access to it, and they in dire financial need but can't have access to the money because the person dealing with the estate doesn't have insight into their needs and empathy for their needs.
And you're in a system and you got to go through, right?
Exactly. You don't have somebody who's looking at your particular set of needs. They're working on a checkbox, and no personal contact or interaction.
And that's something that actually happened this morning, is following up on a estate payout. Obviously, we've put a claim against the estate, just call it one of the major banks. And the gentleman got back to us and he said, no, they've renounced it. What does that mean? When they renounce, does that mean that there's no money? Does that mean that they've put their hands up and said, we're done dealing with this case?
It generally means that the value of the estate is such that the 3.5% isn't enough. Because so an executor can renounce his or her appointment, and that basically means that they're saying, I decline to be appointed as executor. Then the family or the beneficiaries would then need to nominate somebody to be appointed. And when it comes to institutions, it's generally a sort of value threshold at which they would renounce or accept the appointment.
So that means someone else will be doing the executorship of that estate.
Correct.
Well, I hope so, so we can claim our money back.
Yes.
Robin, everything's changing. This whole digital world that we live in, everyone's got social media accounts. People are investing their money into crypto and stuff like that. Do you think it's vitally important for someone to list their password? So bank account passwords, maybe a Lunar app or some sort of cryptocurrency app. Should they list that in their will? So if something should happen, that the family or the attorney has got access to this digital world.
So I wouldn't list it in the will, because those passwords and things may change over time and accounts may change over time. But I would certainly ensure that wherever the will is, there's a document attached with that information, with lists of bank accounts and policies and investments and so forth, and particularly cryptocurrency. Because cryptocurrency isn't regulated in any form at present, there's no way of tracking it. So if somebody dies, if a person dies and you think, well, they may have had cryptocurrency, you can't send an email to every cryptocurrency dealer and ask if this person had cryptocurrency, because they won't know. The only way you can access your cryptocurrency is with your username and password. And I'm aware of a couple of instances where people have been known to have cryptocurrency, but it's in the ether, the beneficiaries can't get their hands on it. When it comes to bank accounts and investments, it's not as important, because if we don't, many people have got good filing systems, so when they've passed away, we can go through their filing systems and see what their assets are and where their accounts are held and so forth. If we're unsure, and as a matter of course, we would send an email to the major banks with a copy of the death certificate saying, did this person have any accounts with you? And they'll either come back and say, yes, they did, and send us, these are our requirements, or they'll say they didn't. So with banks, that's our sort of go-to. We generally do that. But it is an idea, and it's helpful for the executor. I have clients who are very well organized, and once a year they send me a list of their bank accounts and investments and policies and that sort of thing, and I file that with their will. So if they were to pass away, then my job is a lot easier to find things. On many occasions over the years, we've had situations where we've wound up an estate and years have gone by, and an asset pops up, it transpires that the person had shares in Sanlam or whoever, and then we reopen the estate and deal with that. I had an interesting matter fairly recently where a lady passed away, a long-standing client of mine. She had sold her house, bought a new house, and she passed away and left an estate worth about 2.5 million rand. And I thought, well, she didn't do badly. And we wound up the estate. I paid her. Granddaughter was the beneficiary. I paid her. A week later, I got an email from Assupol saying that they've tracked me through the I mentioned earlier that you have those advertisements.
Yes.
You advertise for debtors and creditors. So they had found an advertisement dealing with this lady's estate, with my details as the executor. And it turned out that 5 years ago, she had taken out a single premium endowment policy for 2 million rand.
Wow.
That she didn't tell anybody about. So she was one of those clients who didn't send me the list of assets and accounts every year. So her granddaughter got a lovely surprise that there was another
2 million
two million rand for her. But yeah, if Ashupal hadn't taken the trouble to find me, that money would have been lost. And we're in a modern era where information is so freely available. It doesn't happen as often as it would have in the pre-digital age, but there's many instances where if the executor doesn't know where to look for assets and doesn't find assets, those may be lost forever.
Very biblical mandate, seek and ye shall find.
Exactly, yes. Yes.
So tell me, Robin, lots of people have this whole conspiracy about a will takes so long to actually finalize. I mean, not a will, an estate takes so long to finalize. And I can speak from reference of a past family member. Took almost 6 years. Why? What is that? Is it because people aren't organized, like you said, they don't make your jobs easier? Or is it just the process, the master's office is so behind due to COVID?
So there are a couple of reasons why that may happen. One may be because the person's affairs are in such a disarray that it just takes so long to resolve them. It may be that there are a number of outstanding cases, perhaps court cases or things like that, that the deceased person was involved in that need to be resolved. But more often than not, it's an executor who's not doing their job properly. In a busy practice, it's quite tempting to put the deceased estate file at the bottom of the pile. So, if you don't have a dedicated estate department that people are on top of all the time and working on all the time, that can happen.
And SARS, Robin? Is that?
So SARS, not so much. Again, it depends on whether the person's affairs were well ordered. So if there are years of tax returns outstanding that need to be reconciled and brought up to date, that can cause a problem. So with SARS, there's a two-step process. The tax is assessed until the date of death, and then the tax is assessed from date of death till date of finalization of the estate. So the person gets two tax numbers. So you code the estate with SARS as a deceased estate, and then you've got to file the returns up until date of death, and SARS issues an assessment and either pays a refund or issues an assessment for payment up to that date, and then there's a second tax return that gets filed from date of death to date of finalization, and the estate itself pays that. So money or income that would be taxed there would be interest that's earned on money while it's in the estate. So as an executor, if we collect money, we've put it in an estate trust and an estate banking account. That earns interest. That interest is taxed in the hands of the estate. But SARS is generally pretty efficient, and what we tend to do, but having said that, it can take time to finalize those things. But what we do is we make a provision in the liquidation and distribution account for outstanding tax. So we get an assessment or an idea of what we think the tax might be, and we make a provision of 20 or 30 or 50 or 100,000 rand in the liquidation and distribution account, keep that money aside so that we can distribute to the beneficiaries before those tax matters are finalized, because they can take a bit of time. So typically in an average estate, we would be distributing to beneficiaries between 6 and 12 months at the outside.
Wow, that's excellent, Robin. That's really, like I said, personal experience, 6 years. Yes, maybe in the first year there was a payout, but to only get the final sort of payouts 6 years later.
Yeah, that's unusual.
Yeah, I think there was other things involved, but yes. No,
Yes.
I think 6 years, but lots of people come into the office and they say, Gabs, we haven't received money, we're waiting for the estate to wind up. Unfortunately, Tom Keight, we don't wait for estates to pay out due to the fact that everyone's told us the master's office is so behind. So, yeah. Gab, I don't know if you've got any...
We have all different experiences as well in terms of people's winding up of estates. every now and then someone will leave a bequest to the church, and then you never know. Will they come in this financial year or the next financial year? As a family, we had an interesting experience. My aunt lived in Germany for 50 years, but she still had a South African ID number, but didn't have any identity documents. And that held up the estate for an extremely long period of time because we couldn't apply for documents because she was deceased, and they wanted proof of the documentation as a South African. So that delayed it. So I'm sure there are all sorts of technicalities that can
Did she
hold up
pass
the
in
whole
Germany?
thing. No, she passed away in South Africa, yeah.
Because now with this, obviously we do a lot of families that have come from abroad and they've now been here for the last 30 years. There maybe was an engineer from Germany, for example, and then we've got to get an abridged death certificate. But they've got maybe an asset or some money or pension in Germany or wherever, Greece, Italy. We need to get the death certificate apostilled.
That's right, yes.
And you've got to go through DIRCO. And there's certain countries that only accept DIRCO. They don't accept the High Court's apostille. So it's just crazy to know that each country is different when winding up in a state, whether you're a German national, you've got a South African ID, whether you're South African but living in Germany, all these documentations. And people think that it can take 2 days, 3 days. It doesn't work like that. Do you know what I mean? I think you're dealing with bureaucracy.
Yes, absolutely. And those are the circumstances that can cause these lengthy delays.
Is the bureaucracy,
yes,
sorry.
Yes. So when it comes to the master's office, you mentioned that that's often used as an excuse. And it's often a valid excuse, but we find the delays are more with the issuing of letters of executorship than processing the estate itself. I've got an estate, so the master's office has gone onto an online system. So previously you would send your pack of papers in hard copy to the master's office and they would process. And that was great because we would typically, you get a runner who's familiar with the various processes and people at the master's office, and within 2 weeks or a month you'd have your letters of executorship. Those documents are now coded on an electronic platform, Department of Justice electronic system. So you input all the information on this system, and you then upload the documents that you would ordinarily lodge, and that then gets examined on the other end by a master's office official. They issue the letters of executorship, which they then email to you. So there's no physical hard copy paper that's exchanged. But that system, unfortunately, there's a backlog in processing that. I mean, I submitted an estate in Cape Town in November last year, and they've only now processed it, and we're getting the letters of executorship now. When it comes to processing the liquidation and distribution account, we'll wait to see what happens there, because at the moment we're still submitting those in hard copy, and we're getting feedback on that within a couple of weeks or a month at the outset. If that has to be submitted electronically, I don't know whether there'll be delays there. But fortunately, with liquidation and distribution accounts, so the process there, the creditor or beneficiary only has a sort of legal claim to claim money from the executor when the liquidation and distribution account has been approved and lain for inspection and nobody's objected to it. Only at that point is a creditor or a beneficiary entitled as of right to receive their payment or their money. But what we tend to do is, once we've prepared the liquidation and distribution account and submitted, at that point, if we're satisfied that the account's right and that there's no outstanding claims that may come forward, and we then do our payments and distribution at that point, if not earlier. And we can do that. There's nothing against, no law against it. It's just done at our risk. So if at a later stage a claimant comes forward, or somebody objects to the liquidation account and says my claim hasn't been included there, and that claim's valid, then we have the responsibility to then collect the money back from the beneficiaries. But we're pretty careful about that. It's never happened that we've needed to collect money.
Sure.
Well, all I can say is I've been educated. I've learned a lot today. I don't know about you, Gav.
Absolutely.
And I think, again, my industry of work is just, this is so beneficial to me, Robin. So I can't thank you enough for allowing us the space. You've got a beautiful office.
Thank you.
And thank you for sharing your expertise in drafting up wills and dealing with estates. We're really honored to have you. So thank you. Robin, can you just tell the viewers where people can find Draft Your Wills today, guys? Get in touch with Robin. Where can the viewers find you, Robin?
So we are on, our website is www.robintwaddle.co.za. So you can find us there, and our contact details are there.
And Robin, as much as you were a guinea pig for the Cape Epic, you've been a guinea pig for us today, our first guest ever. And such a privilege to have you here, and thank you for your time.
Thanks, Gavin. It's been a privilege to be your first guest.
Well, I just have one concern. The last podcast we did, there was thunder and lightning, and we have a repeat again today. So I'm not sure what God's saying to us. But thank you so much.
Thanks,
Thanks,
you
Gavin.
guys.
Thanks,
Stay
Gabby.
tuned for the next episode, and thank you to Real Global Productions.